Assalamualaikum and greetings to everyone. Today we are going to present our group assignment. We are from group L.
Assalamualaikum and hello. My name is Putri Zira binti Wazlivu. My matrix number is BB22110162. So, as for today, I'm going to present about the main issue in this assignment. First and foremost, the main issue in this case is whether First Bank was justified in rejecting the documents. The question is whether the discrepancy in the document breached the rules of strict compliance under the UCV 600, making the rejection awful. According to UCP 600s, bank must follow strict rules when dealing with letter of credit. It can be seen in Article 14A, which bank must check document carefully and make sure they match exactly with the terms of the letter of credit. Any small mistake can justify rejection. Other than that, Article 14B also mentioned that document must be presented within the time specific in the credit. Next is Article 16, where it mentioned if document do not meet the requirement, bank have the right to reject them. It can be related with the Article 16C, which the bank must inform the presenter of the rejection and explain the discrepancies. It also mentioned in Article 16D and 16E that the bank can return, keep or handle the document after the rejections. In this case, First Bank found three problems with the document. Firstly, wrong agency for certificate conformity. The certificate was issued by an agency not listed in the letter of credit. Under Article 14A, in the case of Equitability Trust of New York and Dawson Partners, the court said that even small mistake mean the documents do not comply. Secondly, insurance did not cover full value. The insurance certificate only cover 90% of the goods value, but the letter of credit require full value. According to Bank Melly Iron versus Barclay Banks, the court decided that partial compliance is not acceptable. That late presentation of document. The documents were submitted 25 days later after shipping, but the letter of credit required them to be submitted within 15 days. Article 14B and the cases of JH Reiner and Hambros Bank said that the court ruled that late presentation documents invalidate the letter of credits. Lastly, First Bank followed the rules under Article 16. They notified Capital Machinery of the rejection and explained the discrepancies. They also act correctly in handling the documents by returning and retaining them as needed. As for the conclusion, First Bank rejection of the document was justified under UCP 600. The discrepancies using the wrong agency, insufficient insurance, and late submission were clear violation of the letter of credit terms. Strict compliance is required, and court cases show that even small mistakes are not allowed. Because of this breach, Capital Machinery cannot claim payment under his letter of credit. First Bank followed the rules and act lawfully.
The second issue is whether Jaya Construction Sendran Berhad had valid reason for refusing to accept the good. Two main rules apply to this issue, which is free on board (FOB) terms and the contract for the international sales of goods (CISG). Under FOB term, as outlined in Incoterm 2020, the buyer assumes responsibility for the goods once the seller delivers them for shipping. This is crucial in sea or inland waterway transportation. The CISG provides additional rules, including Article 25, which define a fundamental breach of contract as a serious failure to fulfill essential term, depriving the other party of what they were entitled to expect. Article 33B states that goods must be delivered within the agreed time frame unless the contract specifies the otherwise. Under FOB terms, Capital Machinery was responsible for loading 1,000 industrial machines onto a ship at the Port of Sydney provided by Jaya Construction on November 20, 2024. The seller also needed to provide all necessary shipping documents including a clean bill of lading, commercial invoice, insurance certificate, and certificate of conformance. The case of Pyrene Co. versus Skindiat Steam Navigation 1954 illustrates seller responsibility under FOB control, where sellers were held liable for damage during loading even before goods passed the ship's rail. And the next one, under Article 25 of the CISG, a fundamental breach could occur if discrepancies in document, such as incorrect insurance certification or alleged certificate of conformance, materially deprive Jaya Construction of their contractual right. Delci Carrier (SPA) versus Rotorex Corp. 1995 highlight the seriousness of delivering non-conforming goods with damage awarded to failure the meet agreed standard. If Jaya Construction was unable to recover damage due to insurance issue or was significantly delayed in using the machinery, this could constitute a fundamental breach. The last article is Article 33B of the CISG, require delivery within the agreed period. Capital Machinery shipped the goods on November 20 within the stipulated delivery month. Jaya Construction argued delay were caused by incorrect export clearance. If this delay caused the good to arrive late or created significant inconvenience, it could be considered a breach. However, further evidence is needed to determine if the seller action directly caused the delay. The case of Polyamidas di Somantro versus World Elastomer Trade 2013 demonstrate concern a chemical product sales contract. The contract stated that delivery could be in 5 subsequent monthly installments beginning in August 2006, but did not specify the date of each delivery. In conclusion, Jaya Construction claim of late shipment does not appear valid, as the shipment was complete on November 20 within the agreed time frame. However, the claim regarding export clearance require further evidence. Under FOB terms, Capital Machinery was responsible for proper export clearance if Jaya Construction can prove the seller failure to meet the requirement caused the delay. Their refusal to accept the goods might be justified.
Assalamualaikum, my name is Nur Hashima binti Gulam. Today I will be analyzing on the third issue of Capital Machinery versus Jaya Construction. The issue is whether Capital Machinery can claim payment or damage from Jaya Construction for failure to pay and refusal to accept goods. The relevant legal provisions that suits for the issue is from the Contract for the International Sales of Goods 1980 or known as CISG. I'm using three articles from CISG, and the first article is Article 35.1 has highlighted that the article required the seller to deliver goods that conform to the terms of the contract in terms of quantity, quality, and type. The second article is 46.1 allow the buyer to demand specific performance, which is to fulfill the seller obligation. And the last article I'm using is Article 81.1, provide that both parties are released from their obligation, but the affected party can still claim damage. Now, moving on the rules application, in the Article 35.1 has highlighted that the seller must ensure the goods delivery comply with the specification agreed upon the contract. It can be related with the situation when Jaya Construction claim the goods do not conform due to indicate the certification and insurance. However, if the goods meet the contract specification, Jaya Construction refusal to accept them is unjustified. A related case is Rodezalt Helen Tionen versus Rosdown Park, where the goods were rejected for non-conformity. From this case, the Federal Court of the Australia ruled in the favor of the seller, ordering Rosdown and the administrator to pay damage for the wrongful retention of the goods, and the seller was entitled to recover possession of the goods. In addition, in the Article 46.1 has explained that the buyer has the right to demand that the seller fulfill their obligation, such as the delivery of the goods and the necessary document. It can be related if the Jaya Construction believe the goods are non-conforming. This article allowed them to request specific performance, such as correct documentation. However, if Capital Machinery fulfill their obligation, Jaya Construction is still required to pay. A relevant case can be related is Oberland des Garage Mansion 1995. This case has involved where the buyer requests the delivery of the goods that were in conformity with the contract. The seller had the delivery goods which were not in conformity with what was ordered, thus giving the buyer a right to ask for goods in conformity with the contract. The court held that the buyer rights to demand goods that match the contract. And the last but not least, in Article 81.1 has allowed either party to cancel the contract if there is a significant breach, but they can still claim damage. It can be related with the situation if Jaya Construction validly terminate the contract due to a significant breach. They are no longer obligated to perform. However, Capital Machinery can still claim damage for losses caused by the breach. It can be related with the cases of Hong Kong Shipping versus Kawasaki Kaisen Kaisha, which is in this case has established that if a breach is substantial enough to deprive the party of the benefit of the contract, it may justify the cancellation of the contract, but the party cancelling the contract can still claim compensation for any damage suffered. In the conclusion for this issue, Capital Machinery can claim payment or damage from Jaya Construction for failure to pay and refusal to accept the goods, provided the goods delivery conform to the contract if the goods meet the agreed specification. That's all from us. Thank you.